Good evening, ladies and gentlemen. I'm really delighted to be back at my alma mater, the University of Namibia, in a venue that has also shaped my thinking on many issues that we will hopefully interrogate today. I see many faces in the audience, both students whose presence I respect and honor, leaders in public spaces, lawyers of note, and scholars extraordinaire. I really do not take for granted your presence here today, and I'm grateful that you've turned up to engage in this important discourse. The hashtag that we'll be using for purposes of this discussion is Ubuntu through water. So I'm on a book discussion, book launch tour of sorts of about 2 weeks. So please feel free to hashtag any of your thoughts, and we can ensure that the conversation is beyond this room. So I'd like us to get into the meat of discussing and digesting the substance of the book. So I've prepared a few slides to just walk us by way of overview in terms of what the content of the book is. The book's title is Reinvigorating Ubuntu through Water, a Human Rights to Water under the Namibian Constitution. Hopefully, at the end of the presentation, the title of the book will make acute sense to you. So this is just to lay out the water profile of Namibia in terms of the contemporary water needs as well as the debates that are ongoing. Oftentimes we see reports of water disconnections, for example, for non-payment. We've seen the indignity of water scarcity living itself out through reports of people who, while they do not die necessarily of thirst, they do lose their lives when they're seeking to access water. One example such as that of someone digging a well and the well collapsing on them. The situation in the two Okavango regions is particularly also telling, where there are incidences of crocodile snatching human beings who are seeking to access water for daily sustenance. So in order to access this basic need, they have to put at risk limb and often life as well. And of course, the water for profit debate is increasing in intensity, and I'm glad that the newly appointed ombudsperson is here, given that he was quoted recently as having weighed into that debate as to whether or not public water utilities should add a markup when it comes to the provision of water. And of course, that is central to many of these questions. So the situation isn't just one of grimness. There's a lot of water potential. The Hangwena 2 aquifer, and again, I cannot go without acknowledging the presence of the Hangwena governor here. That offering some water potential for the northern regions, particularly that are water poor, and I put that in inverted commas for reasons that will become manifest as the presentation unfolds. Desalination plant prospects, water catchment, such as the Necrotel Dam, which was recently completed, and so forth. So the book is definitely not navel-gazing. It doesn't highlight all the water issues that Namibia is facing and lament them. It identifies them and it recognizes that solutions and remedies ought to be found. So it's solutions-centric and forward-looking in that way, I hope, in an attempt to bring dignity to war in terms of water access. One thing that I also emphasize in the book is that the approach that I take is an anthropocentric one. So I center the human being in these discussions, and human beings from the perspective of water for personal and domestic use, as opposed to water for commercial purposes. And the reason why I centered human beings is because in doing my research, I sought to obviously understand whether there has been some case law as it relates to water rights that is Windhoek court. but I only came across water case law, water rights case law in the commercial context, and some of the examples are identified there. So in Namibia Plains farming, for example, this is Valencia uranium. This was an issue that was before our superior courts, where water for commercial farming was at odds with water for mining purposes. In NAM water versus Alsankia farmers, that was a breach of contract situation where water was being accessed for commercial wine production. And in Kamanya versus Smith, this was a situation where Mr. Kamanya had sought to drill a borehole on his farm in the Omangeti region area in northern Namibia, and Mr. Smith was contracted, and he did not deliver the drilled borehole as contractually agreed. But in all these instances, and there are various others, these commercial contexts, these commercial entities were able to vindicate their water rights before our courts. What I then ask myself is, can someone who, for example, suffers the basic indignity of water inaccessibility, water insecurity, water poverty, bring a similar claim before our courts and seek refuge and protection in our courts in a non-commercial context? So the abridged argument that I pursue in the book, and this is really just to whet your appetites with the view that hopefully you will take time to read the book, is as follows. I argue and conclude that there is indeed a court-enforceable human right to water under our Constitution. Such a right is to be implied from the express right to life in Article 6 of the Constitution. In implying this right to water, I apply various theories of constitutional interpretation, originalism, where I look at the drafting history of the Namibian Constitution. Those of yester generations will recognize also that the 1982 principles played a significant role. What the 1982 principles, which were effectively the foundational instruments that our Constitution was drafted upon before the adoption of the SWAPO draft of the Constitution, what they say about social and economic imperatives such as water, textualism, looking closely at the text of the Constitution, purposivism, as well as transformative constitutionalism, the Constitution as a vehicle for transformation in society. I am dissatisfied in the book with these theories of constitutional interpretation, in as much as I think that they have a role to play, and hence the reason why I, in the book, developed a novel conception of reinvigorative constitutionalism, which basically invites us to reinvigorate African values in our legal culture. In terms of reinvigorative constitutionalism, I think it's worth pausing on this rather theoretical and ideological premise, but quite important, particularly in the scholarly and academic context that we find ourselves in. So decolonial theory is at the heart of reinvigorative constitutionalism. The attempt here is to demonstrate the viability and value of human rights from an African perspective. I assert that in pursuing an Afrocentric approach to the project of human rights, we can infuse human rights with greater cultural legitimacy, both from a knowledge point of view, tapping into indigenous African justice systems, as well as ensuring that human rights carry domestic autochthonous legitimacy for local populations. And that quote there, and I won't repeat it fully, is just to capture that essence of why cultural legitimacy is extremely important in the context of human rights pursuits. Now, under the umbrella of reinvigorative constitutionalism, I utilize the value of Ubuntu as the normative anchor for carrying forward an approach to human rights such as life that includes social economic dimensions. Ubuntu, obviously, of isiZulu, a language extraction. I am because we are. It's a value, concept, philosophy. I move away from common law approaches to water rights. We have contiguous parties that share a river resource. The riparian doctrine would resolve how water resources are utilized there. I stress that we have our own tools through values, norms, and so forth that can help us reconcile some of those difficult questions. I then extrapolate with the help of existing scholarly literature 4 principles of Ubuntu, which I term as legal Ubuntu: solidarity, community, interdependence, and dignity. And most importantly, I stress that the values of Ubuntu then impose certain obligations upon third parties. And in my study, in my research, and in the book, the focus is on the state as the primary duty bearer. And not to say that there are non-state actors and other actors who also bear responsibilities as regards the realization of socio-economic imperatives, but for purposes of the book, the state is the central duty bearer. From a respect, protect, and fulfill point of view, eroding this notion of negative duties as opposed to positive duties, negative duties being those duties to refrain from interference. I stress that there are positive duties of provision that the state must fulfill. A brief socio-economic profile of Namibia is perhaps appropriate in this context. So the legal minds in the room will know that Chapter 3 has an emphasis on civil and political rights, life, dignity, free speech, political activity, and so forth. There's limited reference to social and economic rights. We have the directive principle of state policy, which I deal with in the justiciability part of the discussion, and these social economic rights are water, housing, food, healthcare, sanitation, and so forth, so they don't feature expressly in our constitution, whereas in other constitutions they do feature. And in actual fact, the world is moving ahead where there's more vigorous debate in academic circles, and as I'm sure the panel will remark, around a right to electricity, for example, as a matter of human right, that there is a duty, or a right to the internet, where there's a recognition that in this day and age, without access to the internet, effectively your other fundamental rights, whether civil or political or socio-economic, would be irreducibly eroded to the point of being superfluous and meaningless. So we as Namibia are perhaps behind the curve in the sense that we're focusing on socio-economic rights such as water, when the world is significant steps ahead in terms of the right to the internet, the right to electricity, and such technology-based resources as fundamental rights. So I seek to erode this conception of socio-economic matters being within the exclusive domain of government political programs and policies, and stress that the courts have an oversight function, accountability, and enforcement function, or can have such a function when it comes to enforcing the rights. The book also draws a lot on comparative perspectives, so you will find that there are various comparative decisions that I rely on, and I think I've provided at least a robust foundational methodological approach to comparativism that I justify using our local jurisprudence. Yes, I do look over the fence, as it were, to see what other countries are doing, but that is within a principled framework. So South Africa, for example, has an express right to water in their constitution. There's this decision of Mazibuko versus Johannesburg City Council, Johannesburg municipality, and in that case, effectively the Constitutional Court was called to vindicate the rights of township dwellers who were adversely affected by a water policy in terms of quantity of access to water by the Johannesburg City Council. And the court, in many ways, came to the aid of that community, in as much as scholars have critiqued that decision as not necessarily going far enough. But I also stress that perhaps looking right across the fence to our neighboring country of Botswana, which is a comparator that isn't necessarily prevalent in our comparative jurisprudence, may be more apt because Botswana doesn't have an express right to water, but their superior through this decision of Dr Ndeunyema versus Attorney General, where basically the Baswara community were deprived of the use of an existing borehole by the government of Botswana because of a policy that related to the relocation of that community for the creation of a reserve, and they brought the matter before the court, and the court found that there was a violation of their right not to be subjected to cruel, inhumane, and degrading treatment because of an issue that had a genesis in their ability to access water. So that's an indirect way of perhaps achieving the same outcome, but using the tools and the textual anchorage that is at your disposal. Equally so, Indian jurisprudence, quite rich, also does not have express socio-economic rights in their constitution, but the Supreme Court of India has progressively developed jurisprudence that has found such decisions. And this fluoride decision is a pertinent example, perhaps relevant in the Namibian context, because we do have water sources that are high in terms of milligram content of fluoride, and there is potentially an argument to be made that there is a duty upon the state, a local authority, or any other actor, as it were, to ensure that such water is, in actual fact, consumable. So in the book, I'm also conscious of the fact that the water issue is a global concern. Water stress is an international phenomenon. It's only going to become more pronounced as the years progress, especially with climate change. The World Economic Forum ad nauseum references water as a high-risk issue around the world, and there are increasing legal arguments for a right to water to be recognized as in an express instrument. And I explore this question separately in a paper that I published in the Michigan Journal of International Law, for those who would like to follow up, where I look at water under the various sources of international law. In the book, I do also look at regional treaties such as the African Charter on Human and People's Rights. I recognize that there are trans-boundary water concerns. For example, shared water resources in the Namibian Angolan dispute, if you want, in terms of much of the catchment area for water that is used in the northern regions flows from South Africa, from Angola. Is there a right to water argument that can be made in favor of Namibia in terms of ensuring that Angola does not limit the flow of water to those regions? The dispute between Namibia and South Africa around the ownership, if you want, of the Orange River and where the boundaries are. Is it north of the Orange River, meaning that if it's north and South Africa owns the entire Orange River, both water sources as well as potential mineral deposits, what are the implications there, as opposed to an equidistant approach where the border would lie in the center of the river? All those are issues in the international context, and of course in the African context we have the Nile River that has for centuries, perhaps millennia, been the subject of disputes as regards the free flow thereof. And of course this privatization of water debate is one that has been rife over the last 40 decades or so, where in the 80s we obviously saw that process of neoliberalism, privatization, so private investment into water infrastructure and so forth, and subsequent nationalization by the state, the investors taking certain states, Argentina, Tanzania, Bolivia, and so forth, to international dispute settlement bodies in order to argue. And one of the arguments that they have put forward for purposes of nationalization is that nationalization of water infrastructure particularly was in order to preserve the rights to water of their local populations. Exit jurisprudence on that is mixed in terms of buying into the existence of an international law-based right to water. So in as much as we may be looking at these issues in a somewhat limited focus of our domestic context, we definitely should not have or lose sight of the global context where water stress competition is only going to be more pronounced. And of course, in the United States, they're having the whole debate around the commodification of water sources in California, a water poor region, and water sources, for example, are listed on stock exchanges. And of course, that can create a myriad of challenges if we're not sensitive to the inequality dimensions that are brought to the fore thereof. In the book, I also complicate this issue of water scarcity that is often at the tip of one's tongue when you think of water in Namibia. Because naturally, yes, we're an arid country. Many parts receive little to no rainfall. So when one states that there is a court-enforceable right to water, it's not an invitation for the courts to make it rain, as it were, because obviously courts do not require or cannot induce the impossible. However, I rely on scholarship, particularly a conceptual approach of Leif Alston that relates to first-order scarcity as opposed to second-order scarcity. First-order scarcity is the factual, physical limited nature of a given resource, in our context, water. Now, many resources are inherently limited. So first-order scarcity always exists. It's only a matter of degree of limited availability. But many a times, the difficulty lies with second-order scarcity, where, yes, there is first-order scarcity to varying degrees, but the main issue there is our adaptive capacity to manage that first-order scarcity through the institutions, through the mechanisms that we develop as society. So my argument there, for purposes of the court-enforceable approach, is that I view courts as one of the mechanisms, not exclusively the mechanism, but one of the key mechanisms for managing second-order scarcity in order to ensure accountability, oversight, particularly when it comes to these sensitive distributive questions that I argue should not necessarily be the exclusive domain of policymakers, elected or otherwise. And this issue of technical justiciability also features in the book. So justiciability is basically one's ability to bring a matter for enforcement before a court. So courts may be argued to be illegitimate to deal with issues that are polycentric, that relate to policy, that relate to cultural matters, as water often impacts, that relates to resource allocation, as opposed to the other two organs of the state, the legislature and the executive. The legislature being elected and therefore having the purported legitimacy through the periodic ballots that we subject ourselves to, as well as the fact that many of these questions, as it relates to water and other resources, are technical questions that require expertise, scientific and otherwise, in order to inform them properly. So would courts necessarily be able to adjudicate such a matter that is not necessarily legal in its foundational purposes? And I argue that yes, they do have the capacity and the competency to deal with such matters, as has been seen in other jurisdictions. In so doing, I put forward this notion of bounded deliberative democracy, where, in a nutshell, the courts are a forum for the resolution of these disputes, where both the executive and legislature are within this culture of justification that we've ushered in through the Constitution, held to account through various mechanisms in a manner that isn't necessarily adversarial, but one that prioritizes equity, particularly for those who are on the receiving end of power imbalances in society. The book also stresses that in as much as we assert that there is a court-enforceable human right to water, we should be aware of those issues that can to as this optical illusion, where yes, you have a right to water, but in actual fact, in reality, you do not have meaningful access to such a right because of the design of court processes, legal costs being prohibitive, the adversarial model, legal standing issues, and so forth. So all those issues would perhaps need to be addressed if we are to fully realize a court-enforceable human right to water. And I think the cover of the book, which I hope you do get an opportunity to look at closely if you acquire a copy of the book, is demonstrative of this, because at the cover there, and this image was captured quite astutely by one of our local photographers, Azo Photography. So there's this petrified tree with no leaves in a body of water in an arid environment, yet there's a large body of water. The tree is leafless. Trees in our African context are metaphorical in terms of the resolution of disputes, but you clearly cannot resolve a dispute in that tree because it offers us no refuge in terms of leaves. So how do we ensure that a tree such as this, and reflecting back to the issue of second order scarcity, can meaningfully benefit from the resources around it and not remain petrified as it currently is? And of course you see that mirage reflection, which is an optical illusion where you can't necessarily see where the branches and trunk of the tree starts, and if you look at the book upside down, it also looks like it's a picture that is consonant and so forth. But I also invite you as the reader, come owner of a copy of the book, to give your own metaphorical and artistic interpretation as hopefully you consume the book. And that's not an invitation for you to judge the book by its cover. But if you did, I don't think you'd be disappointed. Penultimately, I also focus on what the content of a right to water is. And I use various sources, the WHO Drinking Water Guidelines, General Comment 15, the African Commission has Nairobi Principles, which outline socio-economic dimensions and so forth. I typologize in an act of remarkable innovation, this aqua notion, which is water that is available, of quality and accessible. I, of course, identify the state as a primary duty bearer. I crucially identify the essential content of a right, which is also synonymous with the minimum core. Minimum core being a common conception in international human rights, finding application in regional and domestic instruments. Basically, each and every right, each and every fundamental right has a core that is non-derogable and a circumjacent that can be derogated from for a particular period of time in as much as there are certain obligations. But this core is particularly pertinent because there are individuals and communities in Namibia from a water perspective whose core right to water is not being realized. And that under our constitutional framework, and I use the express language of the Constitution by looking at Article 22A, which refers to the essential content of a right in Chapter 3 being non-derogable. So, for example, Supreme Court decision, I think it was Minister of Justice versus Alexander. So in that context, it was an extradition application. The Extradition Act at the time prohibited anyone who was facing extradition proceedings from being granted bail, absolutely. The Supreme Court then used that language of Article 22A to say that, yes, you can limit someone's right to liberty, which is a fundamental right, but there is a core that you cannot limit. So by placing an absolute statutory prohibition on granting extradition, then you have derogated from that non-derogable essential content. So applied to the water context, I equally argue that every individual and community has a core right, which is immediate, that is not subject to progressive realization or programmatic formulation or anything of that nature. And as a matter of first recourse, and perhaps as low-hanging fruit, they can vindicate or So that is the end of the substantive presentation, but the concluding slide is perhaps one that is reflected on, I think, page Roman numeral 5 of the book, and that's the dedication of the book. I opened my remarks with saying that this is somewhat of a homecoming to me, or for me, in terms of launching my book here at the University of Namibia, and I expressly dedicate the book to a dear friend, in many ways a mother, a mentor, and so forth, Professor Eva Okupa, who is now late. She was a professor of law here from the early 90s until her demise in 2018. She, in many ways, inspired my academic journey. She provided opportunity. She induced confidence in me and many others who I also see around the room. And I had the bittersweet privilege of seeing her in the very latter weeks of before her demise, when illness kicked in. And I recall her walking me down the streets of London. At the time, I was keenly seeking to secure PhD funding, in as much as I had a spot to continue my studies. And her instruction at the time was that over her dead body would I leave the United Kingdom and Oxford University without a PhD. Now, any of you who know Professor Okupa in the room would know that her words cannot be transgressed. And even posthumously, I did want to honor that memory of her. Hopefully, she is delighted with the outcome of the PhD being this publication that will hopefully be an instrument that can realize dignity for many more Namibians. With that, thank you very much. I look forward to the discussions. Please continue engaging in this conversation through the hashtags indicated. Please do feel free to reach out to me, and of course the book will be available at your pleasure. Many thanks.